The topics are going to relate to the impact of the coronavirus on both current and future projects. Now, what types of costs are generally incurred? Well, in general, we've seen a lot of construction projects that have been suspended as a result of COVID-19. And then ultimately, those projects were restarted. Most of that in Pennsylvania, the restart started in early April. But there have been significant costs that have impacted contractors as a result of modified means and methods. In addition, as a result of the suspension, there have been additional costs incurred as a result of a longer performance period. For example, contractors may have been forced to demobilize and remobilize to a site. Contractors may be experiencing material price escalation costs, particularly as we have seen reduced supplies from certain construction goods, particularly those that have been imported. In addition, contractors have incurred labor rate escalation, and projects in general have incurred extended general conditions. And when you hear the phrase general conditions, basically what is being referred to are the general costs associated with running a construction project. Everything from job site trailers to porta-johns to copiers, water supply, everything that's needed on a general basis to run a construction project. And obviously, as a result of COVID, there's been an extension of those general conditions. From an owner's perspective, there's also been an impact of loss of revenue as a result of business interruption. For current projects, it may be that an owner was planning on having the project done by a certain date and operating the project at that point in time, but as a result of COVID, there has been a delay in when that new project will be able to open. Now, insurance claims associated with business interruption are beyond the scope of this webinar, but there is litigation out there currently about whether an owner can recover for business interruption based on COVID. Now, in addition, contractors have incurred additional costs associated with their method of performance, what is often referred to in the industry as a contractor's means and methods. And by that, I thought we would take a closer look at what's been done in Pennsylvania. And as I indicated, in early April of 2020, the Pennsylvania Department of Health passed certain regulations that permitted most projects within the Commonwealth to get started again, those that were suspended during the COVID shutdown. Now, some of the restrictions that have been placed on contractors on construction sites is the requiring of social distancing. As everyone knows, 6 feet minimum distance being social distancing, and that needs to be maintained between workers, which, as you might imagine, creates a problem on construction projects for certain work items that simply cannot be performed by having people 6 feet apart. In addition, contractors have incurred additional costs associated with hand washing stations and implementing cleaning and sanitizing protocols at construction sites, where areas are required now by Pennsylvania regulation to be identified and then regularly cleaned and disinfected. Contractors have to ensure that all gatherings are limited to no more than 10 people, and even maintaining that 6-foot social distancing with even 10 or fewer people. Contractors also have to limit tool sharing and sanitize tools that must be shared. Finally, contractors have had to employ job site screening based on CDC guidance to determine if employees are able to work. And they have to take steps to prohibit employees from working if they are showing any symptoms of COVID-19. The initial question is whether COVID-19 is a force majeure event. In terms of the definition of force majeure, it means an unforeseeable circumstance that delays or prevents performance or completion of a contract. Force majeure events have been things like fires or natural disasters, hurricanes, earthquakes. We actually have not seen in recent years the use of a pandemic being viewed as a force majeure event because we simply have not dealt with them on the level of COVID-19. Now, the AIA documents and the consensus docs, which are the two most commonly used standardized construction agreements, neither of those use the term force majeure, but they both contain provisions addressing delays caused by forces that are beyond the contractor's control, which obviously COVID-19 falls under that category. The only remedy that they provide in the event of a force majeure situation is an extension of time. And you may have heard that referred to as a no damages for delay type clause, so that the contractor would be entitled to additional time within which to complete their project, but would not be entitled to additional compensation resulting from that delay. Such an extension would be a claim that a contractor would have to submit in accordance with the claims provision of its contract. Now, specifically as it relates to the AIA document, I wanted to touch on the 201, which are the general conditions document, and I'm referring specifically to the 2017 provision in section 8.3.1, which deals with delays and extension of time. That section indicates that if a contractor is delayed at any time in the commencement or progress of work by other causes beyond the contractor's control, time shall be extended for such reasonable time as the architect may determine. And we believe that most contractors would be able to demonstrate that the impact of COVID-19 satisfies the provision of 8.3.1. But again, that would simply entitle the contractor to an extension of time, not necessarily costs associated with the delays. Unlike the AIA document, which is silent on the issue of pandemics, the consensus docs, specifically number 200, the standard agreement and general conditions between owner and constructor, in section 6.3.1 specifically addresses epidemics. And it indicates that if a constructor or contractor is delayed at any time in the commencement or progress of work by any reason beyond the control of the contractor shall be entitled to an equitable extension of contract time. And then that clause goes on to list examples. And one of the specific examples identified are epidemics. So it seems very clear under the consensus docs that COVID-19 would entitle the contractor to an extension of time. However, the epidemic provision is set forth in subparagraph J of section 6.3.1. And when you look at section 6.3.2, it only provides that the contractor is entitled to additional costs related to items A through D. For example, that would include things like encountering hazardous materials or acts or omissions of an owner or design professional. It would not include an epidemic such as COVID-19. The question is still left as to what happens to these increased costs. We have seen that the only remedy provided for in the construction contracts may be an extension of time for the contractor to perform. However, the contractor may very well be looking to be compensated for the additional costs associated with how their performance has been changed as a result of COVID. In other words, all of the costs that the contractor is incurring with complying with Pennsylvania requirements, and this raises several issues. An owner first needs to determine whether they want to make up, in essence, attempt to make up for the suspension during the March time period by demanding that the contractor accelerate to meet the work deadline set forth in the original schedule. In that event, the owner would likely be facing a claim for acceleration costs that would be asserted by the contractor. The contractor may also attempt to pursue a claim for loss of productivity based on reduced crew sizes in order to comply with the social distancing requirement. Contractors could seek to recover costs associated with personal protection equipment and the sanitizing requirements. The question then becomes whether the contractor has a valid claim for these types of costs. That will depend on the claim language set forth in your specific contract. We are encouraging our clients, both on the contractor and owner side, to make sure that you are specifically tracking these additional costs. Contractors would want to set up separate cost codes to track these costs, therefore preserve their rights to pursue these potential claims. And owners, in turn, should be reviewing these costs that are being tracked and monitor them. Communication on this point really is key. Contractors and owners need to talk about what costs are being incurred, how they're going to be compensated, and how they're going to be tracked. The topics